Welcome to InstaLegal. A very common misconception is that a registered will can't be challenged. Now that's because, unlike other documents, the will speaks from the death of the testator, and thus this aspect introduces an element of solemnity in the decision of the question whether the document propounded is proved to be the last will and testament of the testator. So the question for today's discussion is, can I challenge a registered will? Now, the grounds for challenging a will are many. However, if a will is registered, there are very less grounds on which a registered will can be challenged in the court. Registration itself gives a validity to the will. However, that doesn't mean that it cannot be challenged. The grounds under which a registered will can be challenged are basically the suspicious circumstances which are surrounding a will. If any will which has been made is surrounded by any of the following suspicious circumstances, then in such cases, depending upon the facts and circumstances of a particular case, the will can be set aside even if it is registered. What are basically these suspicious circumstances? Firstly, a testator was not keeping a good health at the time of making the will. That is, the testator should have been in a sound and disposing state of mind when the will has been drafted, executed by him. If, for example, a testator is of an age that he is not able to remember, or the memory power is very less, then in such cases that becomes a suspicious circumstance. So in those cases, even if it is a registered will, the same can be questioned if the other party is able to show that the person who was making the will, the testator himself, was not keeping a good health at the time of the making of the will. However, please consider that this alone cannot be a major issue for setting aside a registered will. It has to be corroborated by other circumstances, which could be that a testator has not put the signature on his own free will. Now, how will you devise whether a testator had put the signature on his own free will or not? If in the body of the will, the way the narration of the will has been made, it shows that the testator could not have made such kind of a will, did not have that kind of a knowledge to make that kind of a will, etc., then in that case, the will of the testator to be not free can be assumed by the court if it is challenged. Further, two or more witnesses must have attested the will. Now, if these two witnesses or two or more witnesses are not present, or if there is only one witness who himself is an executor or beneficiary of the will, that is a major suspicious circumstance as held by the Supreme Court in various cases. Further, a narration of the will appears to be unnatural, improbable, or unfair. Now, when will it be unnatural, improbable, or unfair is in the circumstances when the testator is having good relations with all the legal heirs, but to the exclusion of all the legal heirs, if only one beneficiary has been given all the share of the testator, that circumstances, if proven, can be a suspicious circumstance because there is no reason for the testator to not give any share from the properties of himself to the other legal heirs. Also, if the beneficiary himself is made the executor and the beneficiary gets a major share to the exclusion of all the legal heirs without any reason, without the testator not having any bad relationships, or without the testator having bad ill will towards the other legal heirs, it is not understood why the testator would exclude all the other legal heirs but for the beneficiary. So all these circumstances, if are present in a particular registered will, the same can be challenged in the court, and if these circumstances are proved, the registered will be set aside by the court. Thank you very much.